One of the first things that you are hit upon when petitioned by the courts is the language barriers, the very jargon used by the legal entities, the lawyer you hire to confuse things, the uninformed judge that is going to decide things, and the mess you are left with to reinterpret things, or that was missed in the attempt to arrive at a just conclusion. As litigants, we naturally fall prey to the legal system in a court in the end. It is just too difficult to manage alone. Justice denied once again. Today we'll hear from a litigant who has pursued justice and has answers that may help us to making the system easier to deal with. And my guest is Bobby Seeback, who's been unjustly dealt with by the family court. Right, Bobby?
Yes, sir.
Let's start with, these are Bobby's suggestions. I think a lot of them are very good. And you know, one of the things I can say about you is your expertise in the number of years that you've been dealing with this. You've had a lot of successes in family court, and you've done this on your own, pro se, right?
Yes.
Okay. Let's go to number one regarding the pre-printed fill-in-the-blanks forms. I thought that was a great idea because the more consistent you can make something, the more predictable a litigant's future might be by knowing what to expect. So a pre-printed form makes absolute sense to me because people fill out things incorrectly, right?
Many times they do. There are forms on the various sites for the Supreme Court, for the family court, and they have instructions with them, but often you'll have like 17 pages worth of documents when it's not necessary for every case.
Right.
They'll have things that mention military issues if you're in the military. Those are not even necessary for a lot of people. They have things that are specifically for American Indians or Native Americans, which are not specific to every case, but they're still in this pile of documents. Now the average person is going to fill these things out, and then you have to make 5 copies of it. So now you're making copies of all these things for a pro se litigant, someone representing themselves. This could become a very difficult thing.
Without a doubt. I mean, it just made a lot of sense to me that if you pre-printed a form that you wouldn't have to be doing a lot. You could make the copies, I don't know why the copies, by the way. Do you have any idea why they need 5 copies? Or is that for every person in the world to see?
Well, it's so that the judge has a copy. So if there's a children's attorney involved, that person will have a copy.
And then each side of the...
Any experts that may be involved would probably need a copy. And then each side always has to have a copy of everything.
Right, the opposing side, right. What are some of the reasons for courts providing litigants with boilerplate, easy to read and understand pre-printed forms? Not just the fill-in blanks we talked about, but everything else. Because I had, every time I look at these things, I pull my hair out. It's very hard to understand, as I mentioned in the opening regarding jargon, the legal jargon that they use. It can easily be read and understood differently by different people. So there should be something that's explained or explainable. Am I right?
Yes, in the law itself, all these things are supposed to be what they call concrete language. They're supposed to use words that only mean one thing in a particular context, not something that can be,
interpreted different ways.
Interpreted different ways. If apples are apples, you can't put it on the fruit. It's apples, or it's oranges, or it's pears.
So why then do they do that? I mean, why then do they make it to use words that are vague?
They're not supposed to. And appellate decisions don't do that. They judge everything based on other cases, which is a very smart way to do things. You might, for example, have your paperwork dismissed for failing to state a cause of action. And when you made it on forms that were given to you by the court, you say to yourself, well, it should be stating a cause of action. It's not whether you stated it or not. It's whether you have one. And that's what the judge should be looking at, not whether or not you stated it. And so a boilerplate page that actually explains what the cause of action is, whether it's a cause of action for custody or a cause of action
For access or whatever, visitation, whatever. Yeah.
for visitation or for child support, whatever it is, they should have help for everyone.
Okay, and then you have the use of law libraries is not only hardly available, but it's sometimes not available, right? It's
Well, they're available during the week, 9 to 5.
when
pretty much,
everybody else works, in other words.
when everybody's working, and litigants don't have a chance to go in there and do research. And I think that more people would come to terms if they could go in and do research and see what the laws are.
I always, when I looked at case law before and tried to interpret what the case law was meaning in cases that I have tried to manage, and this is not easy to do as a non-lawyer, but I get the idea. But they're not always so exact, and sometimes they're vague, and sometimes they don't really answer the issues in a way that's satisfactory to me as somebody who was going through it. Like when I went through my own situation years ago, many years ago, I had looked at the case law and I'd say, well, that has some semblance of my situation, and this one has very little, but you know, this one has basically none, and this one has a lot, but it's missing this. I could never find one that was exactly my situation. So why do we always resort to case law? I
Well,
mean, there's really
because
no option with case law state, I know, but
Things that the appellate division and the courts and the legislation work by are the rules of the court, the laws that are in place, statutes,
statutes, yeah.
and each case that's decided, and each case that is decided by the appellate division is put into these volumes that you see lining the walls of the law library, of lawyers' offices oftentimes, and they are just other cases that were decided, and when cases are decided a certain way, they become part of what's normal. And they're supposed to look all this stuff up when they make a decision.
How is it categorized in the law libraries when you look at it? Is it, say, when you're looking it up in the library, let's say access, right? Access or visitation, whatever they want to call it. I think they call it visitation. Access or visitation. And then you have the cases that were gone through the appellate process and have a decision was made that pertained to your situation. Fair enough to describe?
That's fair enough.
Okay.
Well, the main thing is to identify the things that your case is about. What is it that you're litigating? And all of that should be in pleadings. Pleading is basically a framework of what your case is about. And the other side gets to make their pleadings, but once those pleadings are put in, that really should be it. There should be no outside issues that are brought in at the last minute. A lot of times when they wind up in court, lawyers will start talking at conferences that are set up for scheduling. Well, that's basically ambushing you at court because they bring up things that you weren't expecting. Nothing should be a surprise in court.
Right.
And that is the biggest surprise that most people go through, and the toughest thing is because you expect a divorce to be cut and dry or separation to be cut and dry. And
Easy to
these are the
determine.
issues, and it winds up being way more than that. They start appointing experts at thousands of dollars. The lawyers themselves start to cost thousands of dollars. And if you can't afford it, well, tough luck.
I found that most people going through court can't afford court. I mean, there's very few people who can afford, as if they had superfluous funds, or disposable income is the word that they use. A lot of people don't know where the threshold is of disposable income. For instance, if you have an extra $500 a month, is that the threshold for disposable income? If when you're done with that $500, that might be entertainment you would wish, or pay for a vacation or something. Where does disposable funds start and end? It's a hard line to establish, isn't it?
It is very difficult. They judge it by supposedly.
I don't
but
think they really give a
necessities.
Yeah,
What is a necessity?
right.
Is a phone a necessity?
Oh my
Is-
God, yeah.
You know, a 5-phone plan that costs a few $100s, is that a necessity or is that a luxury?
Go on forever.
Yeah.
Let's go to visitation as an enforcement. You was mentioning here that visitation orders should be strictly enforced by local authorities as orders for child support and orders of protection are. I mean, that makes a lot of sense to me.
Well, when it comes to child support orders, they're strictly enforced. They have a whole unit just to enforce child support orders.
Right.
People that will help you with paperwork, people that will help you file, people that will collect the money for you. If you have a temporary order of protection, let's say, they have a special division who will enforce those orders. But many times when it comes to visitation,
When you get right down to it, that's more important than most of the other things that they're chasing
it's
down.
the most important thing for children,
Right.
and there's nobody to enforce. You can look all over online. There's hardly anything to help you get enforcement.
It really
You
hit-
should be able to call the sheriff and say, I have an order. The order is not being adhered to. Can you please enforce this order?
Right.
They sometimes won't do that.
No, they
I've
don't. For
called
the longest time, they haven't done
Police
that.
stations to try to get them to
Sure.
get involved, and sometimes they will do some things, but they're reluctant.
It's a great idea. That's something everybody should know about the enforcing the visitation is
Having a piece of paper that says court order means nothing if there's nobody to enforce it.
What about the audio-visual recordings? I mean, we've always purported that. I think it's important to have everything that's said on and recordable, so that we all know what was said on the air. Because people are taking advantage of litigants, you know, in the process of law in a court. When you're not able to know exactly what was said, you wouldn't need minutes then if you were able to visualize. You wouldn't have to pay for something else. Right now, litigants are forced to pay for minutes.
Well, you're forced to pay for the transcripts if you want to buy them, but
Right.
they're expensive.
Right.
They could be up to thousands of dollars, depending on how many days you spend in court.
So what's the value of the filming?
Filming it could keep it to be more accurate, and they can always make a transcript of that. And they do often use electronics means of recording it anyway. And then you would have to get somebody to transcribe it.
It's a major
my terms was if you want to present evidence, they don't even have, let's say, a video player for you to play a video. They have nothing for you to present photographic evidence.
Stenographer, if you're in the middle, that's about all you have is what somebody interprets by stenographer.
And, you know, like they say, a picture tells 1,000 words. If you can go in and use a laptop computer, let's say, to hook up to audio gear,
Yeah.
it's a lot easier than having to lug all that stuff with you.
Let's head towards something else. Lawyers not be appointed where there is a conflict of interest. Conflict of interest is pretty important. I mean, there's judges that receive donations from lawyers, and if you're in front of a judge that you're on the opposing side to that lawyer that donates to his campaign, you're going to have trouble winning that case. We've known many cases that were like that.
Well, I think that a separate entity should appoint the lawyers to litigants that go in and apply for a free lawyer. You should be able to have a free lawyer that is going to honestly and zealously, strictly represent you, because if the lawyer has appeared before that judge many times before and is appointed by that judge, the chances are they're going to want to please the judge more than they're going to want to represent you properly.
Right. There's appellate cases, you say, that should not be sent back to the same judge who was previously involved in the case. That's very important, I think.
I believe that if you have a judge that has decided your case and, you know, has either on purpose or, let's say, erred, they call it erring. Well, there's very little to say that they're not going to do that again. And
they can become self-protecting and prejudicial about the case. They can't
very easily.
They can't be open-headed or open-hearted about it.
If it gets overturned, it's not a good thing for a judge. And so what's to say that that judge, if it goes back to them, is not going to hold it against you?
Right. Let's go rapid fire. We got 2 more to go here, and we're running out of time. I want to make sure we get them through. The financial decisions made by judges and magistrates should include an explanation of why they decided fully to the litigants, full explanations to the litigants in terms of the finances and, for that matter, almost anything else, because there's a weakness in the understanding of the litigant to know fully what the language that's been used and also the money that's about to be spent and where it went, that kind of thing. Like a billable chart, like the attorneys have billable charts, charts with phone calls for 20 seconds and charging 5 minutes, or that kind of thing. Things that can be managed. All financial decisions need to be disclosed, I think, and it's better for a client to gather as much information as they can while they're going through this.
They are supposed to all be disclosed. You're supposed to fill out a net worth statement where you list all of your assets. That means property, money, various things that you may have in your favor.
We just did a show with somebody recently who lost a lot of assets because they filled that out. I think sometimes that's left. You need more than an explanation to know why, and I'm always curious to why the people with more money spend more for their lawyers, spend more on the legal fees, I meant. It seems to be that way, and for obvious reasons it does go that way.
If you have money, it helps you, or it can help you, but not always. You can have a lot of money, and if you are not filling out your assets properly, it could take years to bring it out. They could back that stuff up for a very long time.
Well, I know that one of the things I didn't notice, and I really was caught surprised when I went through my situation to know how many improprieties I felt were taken by the system and how much lack of knowledge I had going in. I don't feel dopey at all about that now, missing all those opportunities to learn something. All it was a massively distorted experience for which I can hardly identify a place in it. It just seems like it's what happened? I don't know. I can't relate to anything that happened. It was so far from reality, and it so screwed up my initial access to my own child that they were asking me to visit every other week when I lived in New York and my child lived in Florida. I mean, I said, take the language out. That's not right. They wouldn't do it. They weren't getting paid enough. They knew that it was going to be a quick divorce, so neither one of us had great amounts of money to put into the divorce. So they wanted to get rid of us. They said, no, it's boilerplate. It's okay. You don't have anything to worry about. Well, that screwed me. I only signed it with authority of both attorneys getting together saying it was okay. So both of those attorneys screwed up. So
the toughest thing is finding an attorney. I would say this to everyone. You need to know the right questions to ask an attorney. You need to know if they're going to represent you properly, and how do you know these things?
How would you know if you asked them anyway? I mean,
the only way you know is if you know something and you go to the law library and you study, and you know the questions to ask. You know what you want in your representation, and you know it's fair.
You can get that information. I still wonder about the fairness aspect to it, but how would you know in the law library, first of all, where to even go? What do you file that under? Is that under, you're going to get screwed, pay attention to this section? What do you call that section that says this is what you can expect?
Well, there are books in the law library to explain, let's say, family law or real estate law or any kind of law that you need to look up. There are reference books to be able to do that. There are things called causes of action. Everything has a cause of action that you bring into a court. Let's say your cause of action is for visitation. It will tell you what you need to list in order to get visitation and what things need to be followed. by either side. It explains both sides to you so that you know what the opposing side will have to.
I guess it could be helpful, you know.
It just gives you a little bit of insight. If you know nothing about child custody, it will
Yeah.
tell you what shared parenting it is. It will tell you what
well, that's
a
good.
custodial
Yeah.
parent is.
So those things can be helpful. Where would you find that? Under what section, you know?
well,
Would it
basically-
be custody or?
Each of the libraries is set up differently,
Mm.
but there's one in Nassau County, there's one in Manhattan, there's one in Brooklyn, there
one in
is one
Suffolk.
out in Suffolk,
Right.
and the law librarians can help you with anything that you need to look up.
Okay. Well, last question on my list here. There should be a separate set of rules given to entities and persons who host visitation, whether it be supervised or therapeutic, so that these people know what they can and what they cannot do legally.
Yes, they should know what the court rules are and the rules that they're supposed to follow. Like I've had visitation canceled by a company because the children weren't going in. And that's not a decision that
They should be making.
should be making.
And there's no enforcement at that point.
It has to be made by the court. That's what the court order is.
So if the court order is there and they don't do it, can't they be held responsible?
They should be held responsible.
And they're not? Is that what you're saying?
And in this particular case, they weren't. Maybe in other cases they would be, but they're supposed to know that. The judge cannot delegate. And
Okay.
there's a case called Zephyrin versus Zephyrin that states that judges cannot delegate anything to do with the appointment of visitation.
Okay. We're done with our field of questions here, and the show is about over, but we have about half a minute left for you to go through anything that you wish to remind the audience about that might be helpful that we didn't cover, if there's anything you can think of that we didn't cover.
Well, I think that visitation really should be called parenting time.
Right.
And that's something that a lot of organizations have been working on. And when you have parenting time, it's supposed to be meaningful and consistent. So if you're going to a place or you're having inconsistent time, that's not good for the children.
Right. There's nothing punishable, though. That's the problem. I see that.
And sometimes that needs to be written into the orders.
Right. Okay,
And
that's important. So you write into the order a
Yes,
functioning
a schedule, a parenting
that-
schedule.
and that a subsequent penalty of some kind should be had for those people that don't accomplish that, right or wrong?
Well, yes, there are contempt things, but people are rarely held in contempt.
I know.
They're giving a chance to purge their contempt by fulfilling the order once they do it, but you have to go through a lot of, you got to jump through a lot of hoops to
You're
to
not
get to
kidding.
that point.
I'll tell you, it's such a convoluted system. The family court is where a lot of people take advantage of. A lot of lawyers and judges take advantage of litigants, and that's the reason why we had you here to the show. So it's family law, unjust and overcomplicated, and I hope that Bobby's simplification rules work well for you to consider when and if, and hopefully not, that you end up in a family court someplace in your town. Thank you very much, Bobby Seeback.
I would recommend mediation as a very last,
Yeah.
as the first thing to try. And
Absolutely, yeah. It's certainly the way to go. I mean, you can avoid all of this by mediating. There's no doubt about that. You've been watching FIT TV, the program that brings you behind the scenes of the divorce culture at FIT. We know you cannot get this information on your own, so we'll bring it to your TV every single week. Of course, we always invite all opposing views. My name is Chris DiMaggio. Thank you for watching FIT TV, and we'll see you again next week.